It was always told to me, including by Sergeant Ramsey the other day, that Captain John Bonifair was the one who wired Mohammed Shiade. In light of the fact that I never had a chance to personally depose Captain Bonifair, I wasn't able to delve into this as much as I would have liked. So we're asking for a chance to get Officer Reinhold into court to get some final testimony, Judge. And I can't imagine that taking more than 5 minutes. I can try and arrange that for tomorrow morning.
You mean final testimony on this motion?
Yes, Your Honor. Whether or not he was listed, I'm not sure. I was just told by Sergeant Ramsey that Captain Bonifair was the one who actually wired Mohammed Shiade. I just learned in the hallway of Mr. Claypool that that's not the case.
All right, so you don't want to close the evidence on the motion?
Not yet, Judge.
Right,
and if I missed that in one of the depositions, I do apologize. I have had a very short amount of time to prepare in the past month, and
I will, look, any comment from State?
He testified the first trial. I had his trial testimony and he provided him if it's helpful.
Well, let's do this just to kind of keep this moving. Why don't you, if you located Ms. Laurie as a courtesy, if you'd give that to Mr. Rosenfeld. I'll allow you the opportunity, if necessary, to proffer additional evidence from him, but looking at that testimony, you may be able to rely on it, or you may not, I don't know, but I'll give you the opportunity to take a look at this and decide whether you need to submit any additional evidence. Now, just parenthetically, I'll say what the evidence seems to be so far, and I don't know whether his testimony is going to change any of this. It does not appear that there's any conflict in the evidence with respect to whether Mr. Shiade was in fact wired. And if he's the one that just put the wire on, then he's not really adding anything. If he adds something to the malfunction, I suppose he might. But it doesn't seem from the evidence that there's any factual dispute. And I know you want to argue inferences from the logs, but setting the logs aside, with the witnesses that have testified, there doesn't appear to be any factual dispute that he was wired, but there was no recording because of a malfunction or otherwise. So I don't know whether he's going to add anything to that or not. I'll let Ms. Laurie give you some cite to the prior trial testimony, and I'll work it in sometime. When, I don't know. I'm going to keep this moving forward, so I'll try to work it in. It might have to be very short testimony before we commence with any other proceedings in the morning. I don't know. So
that's fine, Your Honor. Yeah, I guess our only concern, and it might be resolved in the trial transcript, is that everything we've heard about the malfunction has been through what somebody has told Captain Bonifair, through what somebody has told Sergeant Ramsey. So it seems like the only person who would know about the malfunction or have first-hand knowledge would be Officer Reinhold or possibly Sergeant Sheridan. But in light of the fact that Officer Reinhold was the one who actually wired him, he would have the most knowledge of that.
I'll give you that opportunity.
All right, so I'll take a look at that. Maybe it's unnecessary, Judge.
Depends on what his testimony would be. I mean, I'm still looking, obviously, and you want to argue inference from the logs. I'm obviously, my perspective, I'm still looking for evidence that it existed. So, but I'll give you that. I'll give you that chance to run it to ground.
Oh, we appreciate that, Judge.
Okay. All right. I feel like I know we've got the motion to suppress that we need to finish. I really think we probably ought to get to the motion to change venue now, because I want to get that heard before I go further into jury selection, obviously. So why don't we? I know you're all wired up to play your disc, but I think we need to jump. We need to jump ahead to that, I think.
We actually are still trying to print the motion. Wilkins didn't see it until this morning. Give us 5 minutes.
Yeah, I think I had an extra copy of it. Yeah, I ended up printing it. I think it was sent to me at like 10:50 last night.
Yeah, we're sorry about that. We worked around the clock.
I printed it, but then I think my judicial assistant also brought me in a copy that was sent to the CAD. So if you need a copy, I can get you a copy.
I have it. I just have to separate.
All right. Neil? Yeah.
As soon as I get
Yeah, no mystery there. I could have expected that. I think she told him 9, I told him 9:30. Yeah, so that's why we're missing something.
this guy called in, he's real sick, he's going to doctors, he's going to fax him to doctors.
So how much longer do you think you're going to require? Yeah, I mean, no, I know, I don't want to cut you off, but the argument is basically Rawling versus State v. Knight. I mean, it's just those factors is the argument, but. Yes, actually, the sixth one, I think, comes out of federal case law. But in any event, State v. Knight has a fifth that's not in here. But it's not, I mean, it's basically those factors. All right, well, let's just go ahead and get started. Mr. Rosenfeld, are you arguing the motion? Or is Mr. Claypool? All right, Mr. Claypool, go ahead.
Good morning. You submitted a brief over the weekend, Your Honor, of a motion to change venue, so I'm not going to reciprocate all the laws cited in the brief. I would like to add a couple things. I think this is the poster child case for a change of venue being granted. The factors that the courts in Florida consider for granting a change of venue, the multi-factor test, every factor, I think, applies in this case. The first factor, the size and saturation level of publicity. I mean, in Palm Beach County, we've been decimated with publicity over Ms. Dippolito's case. And the trouble we face in trying to pick a fair jury in this county is that every news broadcast, Your Honor, references the history of the case, including the first trial and Ms. Dippolito having been found guilty. I have printed out with me a Google search. You type in Ms. Dippolito's name, every heading mentions here a retrial, which exposes the jury pool to the fact that Ms. Dippolito has previously been convicted. The second factor, the source of the publicity, it's the news media, both in print. We've had many jurors come in here, prospective jurors coming in here saying they watch the news, they listen to the radio. It's been running nonstop in Palm Beach County. And another hurdle we face in picking a fair jury in Palm Beach County, Your Honor, is that each broadcast, again, references, the history of the case, and we can't get around that. And also, we've had many prospective jurors already come in here, Your Honor, who have not been released yet, who have said that they have seen video, for example, the stage crime scene video, or they've seen the cops episode, and they haven't even been removed yet for cause. So one of the factors that courts look at is not only how is the jury selection process going, and it's not, with all due respect, the court's doing a fantastic job. But the fact of the matter is, I think we've had probably 60% of the prospective jurors already eliminated because they formed an opinion of guilt about Ms. Dippolito. But that doesn't even factor in the countless jurors that we're going to question and more than likely remove from this panel for cause because they have seen the stage crime scene video or the cops episode. And just to be clear on the record, our position is going to be that every prospective juror that walks into this courtroom, it says that they've seen the stage crime scene video or they've seen the cops episode or they've seen the interrogation video should be removed from this jury panel for cause. And that, at the end of the day, in this process, is not going to leave us at all with a fair and impartial jury. And I don't even think if we do finish this process and the court's inclined to defer ruling on this motion to see whether we can get a jury, I'm pretty confident that we're not going to get a fair and impartial jury out of the pool that we've interviewed, I think, over 200 jurors. Just quickly, Your Honor, a couple more factors. The continuity of the publicity and whether it can be expected to dissipate. The continuity of the publicity has gotten worse. We've stated facts in our brief that show the volume of media coverage, the number of times that people have viewed the media coverage. It has actually gone up dramatically, especially over the last, since 2011, and then more importantly, since the beginning of last week leading up to jury selection. I mean, nearly every juror's come in here and said they've heard about it or heard about it on in the radio or on TV. So there's not going to be a dissipation in the media coverage. And then the size of the community and expected jury pool. I mean, we need, Your Honor, we need to get jurors from another county. I just think that although there's been some media outside of Palm Beach County, unless you're living, in an igloo, I don't know how you can't be exposed to the fact that this retrial is taking place, number one, and number two, that Ms. Dippolito was previously convicted in the first trial. And then the last factor I've already touched upon, Your Honor, which is the likelihood that voir dire and jury instructions will be successful in ameliorating prejudice. That's not going to happen in this case because I've looked at my list over the weekend and I'm very confident that most of the jurors that we've got coming back have already seen the staged crime scene video. It's prejudicial, or the cops video, and I just don't see how the court can leave these folks on the jury, even if they tell Your Honor, oh, well, I've seen the videos, but I haven't formed an opinion as to Ms. Dippolito's guilt. And that leads to one final point, Your Honor. We had a brief discussion, I think, on Friday, where we were discussing, I think Mr. Rosenfeld had raised an issue, well, we should presume that the jurors that have seen or heard some of the media coverage might not be telling the truth. And I believe Your Honor had said, well, we can't really presume that. We're not at a place where we can presume that. But I do think we have a case on point, Mumin, M-U-M-I-N versus Virginia, 500 U.S. 415, and also Shepard, 384 U.S. at 355, that stands for the proposition that recognizing that when pretrial publicity is pervasive within a community, a juror's claims that they can be impartial should not be believed. And voir dire is an inadequate curative. I believe these cases stand for exactly what we were arguing on Friday, Your Honor, which we can't trust that these prospective jurors coming in here and say, yeah, I heard about it, read about it, but gee, I'm perfectly capable of being fair and impartial. That's just not the case. We're taking a huge risk, and the case we cited stands for the proposition that we need to be proactive and preempt Ms. Dippolito getting a biased jury. So with that said, there's a lot more I could say, but in the brief, trust the court will give serious consideration to this. And I'm hoping that even if the court does defer, that after we find out that we cannot select a jury with the panel of jurors we have, that the court will embrace the 6th and 14th Amendment rights of Ms. Dippolito to a fair and impartial jury. Thank you, Your Honor.
All right, thank you, Mr. Claypool. Ms. Laurie.
To kind of just briefly go through the different factors, I think when we look one at the size of saturation level of publicity, and looking at what a change venue would do, it's reach national news, as the exact state. So when you look at what jurors are supposed to hear versus what jurors are supposed to with any other venue, it's going to be the same amount of publicity, the same type of publicity. So I don't think that that's going to change. We look at the source of the publicity, and 2 and 3, and the inflammatory nature of the publicity, and whether it's balanced or one-sided. I realize that the Boynton Beach Police Department released this video when it went viral when this first happened back in 2009. That's been 7 years ago. Versus now, it is one-sided. It's the defense that's holding press conferences. Unfortunately, Mr. Claypool tweeted as recent as 2 hours ago about this case. Recently was on a news media talking about issues dealing with the case. So when the exposure and publicity that's coming from the case is not coming from the state, it's not a state deal, it's the defense putting this publicity out there. The inflammatory nature, I think with some of these cases, when we look at some of the cases that have been moved, I think they cited to the John McVeigh, the McVeigh case out of Oklahoma. That obviously is a very different situation where you have an active domestic terrorism. And I don't think anyone could set that aside. I know there's a case, and I don't have, I'm trying to find the name of it, that was an incident out of Miami where an individual had other pending murder charges that I believe he might have been convicted on, was facing a death penalty on, and the court reasoned, well, if somebody knew of that, even unrelated, it obviously would create prejudice. And there was an additional case out of Miami, I'm trying to find the case name, that dealt with, I believe it was the Lozano case, where there was a police officer who was charged with the murder of 2 individuals, and there's been rioting throughout Miami. Yes, it's Lozano, it's 584 Southern 2nd 19 out of the 3rd DCA from 1991. And there was a police officer who was charged for the homicide of 2 individuals who were fleeing from the police. They were shot. One was killed, the other died as a resulting crash. The motorcycle they were on. There was rioting throughout Lee County. basically it was presumed that maybe a jury felt that if they didn't return the verdict that society sought, then there would be backlash on them. I don't think that that's the situation here. Yes, this case is garnered attention, but it's not rising to the level of that. The continuity of the publicity and whether it's expected to dissipate, obviously I think we all know that publicity is not going to stop on any case, but I think even if you get a jury from another venue, that factor is still going to exist. The size of the community, we have 1 million people in Palm Beach County. I certainly think that the court can reach further if needed and pull in more people. It's not like we're in a very, very small jurisdiction that has a very, very limited jury pool that we couldn't reach further and pull in more jurors if needed to first exhaust the resources of the county. Number 6, the likelihood that while jury charges would be successful, the court would have to presume that jurors are flat out lying to the court when they say that they can set things aside. I don't think that there's a reason for the court to presume that. There's no evidence that people aren't able to set something aside. People can hear things, and some people have come in and said, yes, I'm biased, I have formulated an opinion, this is what my opinion is. We have person after person say that, which leads you to believe that jurors aren't being untruthful with this court. They are being truthful with this court when we've had to strike people for cause because they've been honest. Therefore, based on that, the people that have said, I can set what knowledge I may have aside or things I may have heard about her aside, there tends to be credibility to that statement. We have 70 people that we've vetted through preliminary vetting of that have been able to come back today. That I think that before the court were to look at changing the venue, there's still the ability to try to seek a valid jury here in Palm Beach County.
Okay, Mr. Claypool, moving party gets the last word.
Yeah, just a couple final comments, Your Honor, moving along. I mean, the Casey Anthony case garnered national media attention as well, and change of venue was granted. The Goodman case, I believe, garnered some national attention. Change of venue was granted. No reason why it can't happen here. I believe the media generated in the Dippolito case eclipses the media, especially in the Goodman case. And also, a brief response, the Boynton Beach PD still has these videos up on its YouTube site. So this is an ongoing dissemination of prejudicial information against my client by law enforcement, and that's a factor that the court's considered. Another factor, I've looked at the list of the prospective jurors we've been interviewing for 2 days. A lot of them live in close proximity to Boynton Beach. They're living right where this happened, and we run a grave risk of not taking a step that the courts have even stated in our brief, the case we cited. It might be somewhat of an inconvenience on the court to do this, but in the end, when you weigh that versus the fundamental constitutional right of my client to get a fair trial, it's not an inconvenience. And I think we're running a big risk at this point in time of, rushing in a frenzy, or not in a frenzy, but we all want to get the job done, want to get this case done and over with, but we can't overlook doing that at the expense of maybe having to come back here a third time. If we don't enact a remedy, it would preempt that. And the only other comment I'd like to make, Your Honor, is I did tweet, and it's about primarily procedurally what's happening in the case, because the community has a right to know that. But that pales in comparison to the blitz of media that has been one-sided. In fact, I didn't mention a book that was written by the former prosecutor. I think it was Poison Candy, something to that effect. So, I mean, this is just, this has to end, and I think we, Your Honor, came here with a fair and open mind, and we've allowed the process to unfold. We didn't try to file this beforehand. We waited. You've done a phenomenal job at vetting these jurors and getting to the bottom of whether they have any bias. And I think, in a way, your being so vigilant in carrying out your duty has led to something that we really can't avoid, which is this is a contaminated jury pool in Palm Beach. Thank you.
All right, thank you, Mr. Claypool. Okay. Look, there is no escaping the fact that this case has garnered pervasive publicity. As they say, it is what it is. You can look for blame if you wish. It doesn't do any good to cast blame. You can go back to the Boynton Beach Police Department. You can blame the media because they're fascinated with this case, both locally and nationally. You can, if you want, blame defense for holding press conferences. But none of that really matters. I have to concede that there is pervasive publicity in the case, and we all have to acknowledge that. We've seen that. I think it probably is much more intense in Palm Beach County than it would be other places, but it has garnered national attention also. So I don't think the publicity problem, while it could be lessened going somewhere else, is going to be completely eliminated. Much of it has been inflammatory. I have to concede that. But here's where I'm at right now. Right now I have 70, it was going to be 71, but I have one that apparently is sick, Juror 39 on the new chart. I have 71 people who have presumptively been qualified and not affected by the publicity. And I think I have an opportunity to seat a fair and impartial jury. If I cannot do that with this group, obviously I have to reconsider whether or not it makes any sense to try to select a jury again in Palm Beach County. With respect to those that have reported some prior knowledge of the case, I do believe that some of those probably are going to rise to a level of for cause, but keep in mind that each of those people observed, saw, read different things. Some had very minor contact with the case in the past. Some that are coming back said they saw the episode on Cops. So there's a varying degree of knowledge with respect to the folks that are coming back that I'm going to have to consider ultimately when I decide any for cause challenges. We also have people reported no knowledge. And so at this point it's premature to grant this motion to change venue. I guess for the record I'll deny it without prejudice. As we go into this process, if I have to conclude that I cannot seat an impartial jury, I will agree, Mr. Claypool, inconvenience of the court is not a basis for denying the motion. The fundamental principle here is that your client is entitled to an impartial jury, and that's my job, to try to seat that impartial jury. If I can't do it here, I can't do it, and I'll have to change what we're going to do going forward. At this point, I think I have an opportunity to do it based on what's occurred. It's been difficult, but I don't think it's at this point impossible. But again, I recognize the due process rights, and they are paramount, and I will take those into consideration as we move forward if I don't think we can seat an impartial jury. Keep in mind that to select a jury in this case, at the end of the day, I have to have 18 people remaining that are impartial, because you each have 6 strikes apiece. I need 6 for the jury. So the magic number in this case at the end of the day is 18. That doesn't include any alternates. If we want to select an alternate, you'll need more. If you want 1 alternate, add 3. If you want 2 alternates, add 6. But that's my task at the end of the day, and I've got 70 people who are still presumptively qualified. So I think it's premature at this time, but I don't think anyone can deny that this case has garnered significant publicity in this county and otherwise. So it's denied without prejudice. We're going to go forward with jury selection, find out where we're at the end of the day. And obviously when we get to the 4 causes, I'll take up the arguments about the Cops video and all that stuff. These people are presumptively based on, and the other thing is with respect to witnesses or jurors that indicate that they can be fair and impartial, part of the jury selection process is for me to evaluate not only what they say, but the manner in which they say it, and make determinations with respect to whether I believe there is any reasonable doubt as to whether or not they in fact can be impartial. And I'll do that through the process. In fact, I've gone back and listened to the testimony of every single juror who's given any type of testimony so far on the issue of publicity. I did over the weekend, so I'm fully aware of what everyone has said in this case, and I'll be prepared to rule on for cause motion or for cause challenges at the appropriate time. So it's denied without prejudice is what I'm saying.
Thank you.
Okay.
And Judge, in light of your ruling, we have 2 quit or tennis motions regarding jury selection today.
Okay.
First would be to strike all jurors who saw the crime scene video, staged crime scene video, saw the Cops video, or read any news whatsoever about this case. Now, I know Your Honor said we could strike them and cause challenges after voir dire today. The problem we run into is Ms. Dippolito's first trial was overturned because we had a jury pool, and one of those jurors spat something out about her trying to poison her husband, some outrageous claim. So basically, he made comments about inadmissible evidence. Now, I know the state said they didn't concede, and there was some question as to how Your Honor ruled on Mr. Claypool and my motion eliminate to exclude.
Not to cut you off, Mr. Rosenfeld, is your concern with respect to waiting on for-cause challenges, as I indicated?
Absolutely.
Well, hang on, I'm trying to define your concern, okay? Is your concern that one of the jurors or potential jurors who express knowledge might say something? Is that your concern?
Oh, absolutely, Judge. I mean, for the same reason why we excused all jurors who had heard about the alleged poisoning, the same rationale goes to jurors who saw this video that you ruled, and you can look at the quarterback form, we can do a playback, was inadmissible. So there's no reason why you shouldn't have struck them already, and the purpose of the first 2 days of voir dire was to address pretrial publicity and to root out people who had prior knowledge. And you seem to strike jurors who knew about one thing you deem was inadmissible, but keep jurors who knew about another thing. And we're gonna, in other words, you struck every juror who heard about the poisoning allegation,
Right.
but you did not strike jurors who heard about the staged crime scene, despite us coming forward and objecting every time. And there's no distinction. You ruled the same on both motions.
I didn't rule on the second motion. They agreed to it. I mean,
And Judge, I insisted, as I do with every motion, that I have a ruling. And we can do a playback, and Your Honor granted the motion.
by agreement. I mean, I didn't. If you want to re-argue the motion, we can re-argue the motion. Mr. Roosevelt, I had thought about this, and what I had planned to do is to instruct this panel that anyone who has already talked to us about having some sort of pre-trial notice, news otherwise, that in response to any question, if they are not permitted to refer to in any way, directly or indirectly, anything that they may have seen or heard in the past, and we will take that up individually. I would agree with you, if something happens, it could cause a loss of the panel. I'm not suggesting that if, depending on what they said, that couldn't happen, but I had already thought of this and was going to give them an instruction in that regard. Because again, different jurors, even with the issue of the so-called fake crime scene, there are different levels of knowledge and understanding and different responses as to each, and I just prefer to wait until we do the for-cause challenges. These people presumptively right now I've not excluded. That doesn't mean they're not going to be excluded. I do not believe there's a necessity at this moment to let them go. I'm not suggesting they may not, but there are a lot of issues that are going to come up real quickly here, and some of these people are going to be eliminated on other bases, along with other jurors, those that can't follow presumption of innocence, those that have a problem with the right to remain silent. There are a whole host of issues we're going to be dealing with all of these jurors, and then I want to consider those all in context at the end, as I always do. And so, to the extent you're asking me for a ruling now that you asked me for before, I'm going to continue to deny that without prejudice, and I'm going to go through jury selection. At the end of the day, I'll decide which ones can stay and which ones cannot.
Well, in the second part of that motion, and Mr. Claypool had eloquently mentioned it in the previous motion, deals with the news coverage. Now, anybody who had said in voir dire already that they saw news coverage about this case, and many of those jurors are still in the jury pool, very well could have seen one of these mini articles that discuss retrial either in the title or in the context of the article. And I'm going to provide Your Honor with a printout from Google. And I want you to see it as well. I have a copy for you. If you read through the blurbs in the bottom, you'll see the same thing. And my concern is this, Judge. My concern is, yes, they said to this court, we saw news articles, or we haven't formulated an opinion. All right, so the only way we can find out whether those were one of the many news articles that discussed the retrial would be by asking them. And we obviously can't ask them that
We asked them, did anyone follow the case? Does anyone know what's been happening in the case? Some said yes. They said they knew it was a second trial. They were immediately eliminated. I'll be honest with you, some of these you didn't even follow up and ask questions of.
Because we can't ask them. I mean, if someone said, you know, I've seen news about, and you asked this, you said you've seen news about the case, have you formulated an opinion? They said no. We have no way of knowing whether that news they read included information about the poisoning or included information about the retrial. The only way to find that out would be to ask them.
But we asked each one of them, what do you recall? What did you read? What did you see? What do you remember? When we asked those questions as to each of these prospective jurors. I mean, basically what you're asking me to do, and I don't think the law supports. Now, you've got individual arguments with respect to individual potential jurors based on the level of their knowledge, what they actually saw, what they said. But what you're basically asking me to do is to strike every single juror who in any way has indicated they had prior knowledge of the case based on news coverage. I don't think the law supports that. I don't believe that is required. I believe I have to go through an assessment of the level of their knowledge, their ability to set that aside, and make judgments about those. And so I'm not going to strike everyone at this time that's raised their hand to say that they have prior knowledge. Again, the level of that knowledge varies quite a bit in this pool. Some have more extensive knowledge than others. Some know hardly anything about it and didn't really even report much about it, but they felt compelled to raise their hand. And so I'm not striking everyone who knew something about the case prior. And again, there is no reason why. I understand your concerns about blurting things out. I'm going to instruct them about that. There is no reason why this argument can't wait till the end, till we see what the body looks like, what we have, what other bases there may be to lead to the exclusion of these jurors and other jurors. That is, wait till the end of the process.
And the last thing I'll say is that the only distinction I draw about the news coverage is the fact that so many of these local articles refer to the retrial. That's, you know, without question a distinction.
You know, Mr.
That's the
Rosen,
last thing I'll say.
No. I'm going to acknowledge that. I mean, I understand your concern, okay, and I understand any juror with knowledge of a retrial. Any juror who knows that there was a prior conviction cannot sit on this jury. We've done our best under the circumstances, I believe, to vet those people out. And I'm not willing at this point to simply exclude everyone who raised their hand initially saying that they had some knowledge of the case. You know, it may be that we seat a jury that is comprised of no one who raised their hands at the end of the day, but I'm going to wait through the process, as I always do, to the end. Presumptively, they're okay for now. Whether they survive further scrutiny, that's an issue for the end of the day.
That's fine, Judge. I mean, you just on a comical note, you'd be shocked, and I guess Mr. Claypool has some benefit here, you know, not living in Palm Beach. I mean, I can't walk down the street and walk my dog without people stopping me. I mean, it happened the other day and saying, "Oh, I saw you on the news about that Dalia Dippolito case." But we'll move on past the argument yet.
Well, I myself have been greeted by more of my friends about appearing on television than I would like also. But
yeah,
that's the fact.
These are strangers. These are even my friends.
That's the fact. For whatever reason, this case has garnished a lot of attention. But I appreciate your arguments. I'm not insensitive to them, but I think that we can go through the process, and in the end, I'll make a decision about those things.
So you're denying without prejudice?
I'm denying without prejudice. You're going to have all your four cause challenges with respect to all these people. You're going to be able to raise. And as I said, I've gone through and listened to what each has said again to have a more current understanding of exactly what they said, what they saw, and my impressions of what they were saying. That is, can I trust what they're saying or not trust what they're saying? And I have some issues with some of them, candidly, but we'll get to those.
And the second argument, the second motion, Ortenis motion, Judge, is Ortenis motion to individually question all jurors again as to what they heard over the weekend. And this was done in the Casey Anthony case. And I say that because Your Honor instructed them not to watch it.
Well, I'm going to ask them that.
Okay, and I'll just tell you the basis of it real quickly. And the reason being, even jurors who followed your instructions could have picked up a paper accidentally and saw it, watching the news and saw it. It's the first thing on every local news channel.
One of the first things I intend to ask this group is, when you came in either on Thursday or Friday, we did ask those that had seen or read something about this case in the past. I don't want to revisit those issues, but I want to know if there's anyone here who now, since the time they were brought in for jury service, has listened to, read, or seen any news coverage of the case? And if you have, I want you to raise your hand, and then we will speak to them individually. Candidly, I plan to do that throughout this trial.
All right, so you're granting?
Yeah, I'm going to do that. I mean, I'm going to do the same hybrid method I did before. I'm not going to bring in 70 people individually and say, did you see something? My inquiry to this group will start with, some of you have reported seeing or knowing something about this case before you came to jury selection. Once you came to jury selection, I gave you instructions. Has anyone, and I'm going to suggest in a way, you don't have to be shy about responding. You could have been inadvertent or whatever reason. Has anyone listened to or read any news accounts of this trial since you've been summoned here for jury service? If so, raise your hand. I will mark that person down. That person will be spoken to individually.
And that's what we were moving forward.
Yeah, I have no problem with that. That's granted.
Thank you, Judge.
Neil, what is the status of our jurors?
Last time I called, Judge, we were missing 5. I'm trying to call down there, but
They're tired of hearing from us. You want to go ahead and play this? Okay. Mr. Roosevelt, we're going to go ahead and play this tape. Oh, yes. Listen, the court reporter has a question, and it really has to do with the appellate records. So I want to get feedback from the attorneys. Court reporter is asking whether or not she should record, take down what is heard on the tape. And it's really up to the attorneys as to what the attorneys believe is the best way to preserve the appellate record. Well, I know, but we're just, we still have to know what we want done. Do you want her to take it down?
I hate to inconvenience her, but I think procedurally she has to.
I think you're correct, Mr. Rosenfeld. I think in order to preserve the appellate record, they want it transcribed. So if you don't mind, and we'll make sure that you can hear.
Hello?
Hey, Omar.
كيف محمد؟ شو رحت ولا؟
Yeah, I رحت كده أنا got evidence والمصاري في إيدي another
شفت البنت يعني ولا لا؟
Yeah, she admitted everything. عطتني المصاري. Now they're calling me back to the police station so they can wire me to evidence.
طيب خلص يمكن أنا أضوي that's good.
I'm not going to sleep knowing.
لكن سامع.
So I'm not going to be able to sleep knowing that someone's going to be killed, you know? I have to get it off my chest.
لا خلص اليوم ينزل.
Good. Pause. What's the objection?
There are several statements made in that portion that are not in English, and without they're required by the administrative rule in Palm Beach County to provide Your Honor with a transcript. Some of those statements made in that segment were made in, I'm not sure what language it was.
I'm not either. Well, Mr. Shader was speaking in English.
No, there was a portion of it where he's speaking in, you know what language it was? Yeah, possibly Arabic. That's the state's obligation, not ours. Who knows what he's saying in Arabic? He could be saying, they forced me into wearing this wire today. We don't know. We heard Arabic there.
Okay, I'm going to overrule to the extent that I can understand the English, although not sure we even have anyone that could translate here Arabic, but I'm sure it can be done. It'll just go to the weight and credibility of the statement. I'm not even sure it tells me much, frankly, to be honest with you. So I'm going to overrule the objection. We're still missing 5, we're down to 3. Okay, what I'm going to do is I'm going to step, do you all have your new maps? The new juror maps?
Yes, sir.
Mr. Rosenman? You're looking puzzled.
You can slid it on the table.
Yeah. I got to step off and get some notes that I have on all of this. So let's take about a 5-minute break. We're going to try to get these folks up here and get started. Okay, so we're missing 3. There's nothing, it's public record. Yeah. So is she one of the ones not here? I thought I had her coming back, but okay. Yeah, I'll check with Mr. Rosenfeld, Mr. Claypool, see what they think about it. Is that one of the ones that's missing?
Yes. Well, she's the fourth one that's missing.
All right, hang on here. 396, 35, not back. Possibly excused. 04. Stuck his head in. Do you know what wells were missing?
No, I'm going to call it.
All right, I'm going to step off for just a minute.
Sorry, properly preserve the record. Our objection to that being played was lack of proper foundation.
Okay. And it was overruled.
All right, thank you, Judge.
Okay. Yes. All right, we'll be in recess for about 5 minutes.
Thanks, Steve. Come to work for the session.
So the jurors know how that got. Okay, let's just, but there are a couple of preliminary things we can do in any event. Just so everyone's aware. We have one juror that's called in sick that we know of, so we're going to have to strike that juror. That would be 3-9, I believe. And then I want to confirm, I have someone coming back that Neil doesn't have coming back, the state doesn't have coming back, so I want to check with the defense. 3-5 is Nibs.
5-9,
On the new list, on the new list.
Do we know what she was, what day she was?
5-9 on the, I can give you the old number.
First day.
It was day 1.
She was caused. Yeah, she was marching for childcare, single mom.
Okay, so she's on this list and should not be. Not on this, let's get clear. She's 3-5 on the new list. She will not be here today. She was excused, and I missed that. So 3-5 will not be here. On the new list, not the old list, on the new list, 3-9 is called in sick. He will not be here. Okay, one more thing. 4, and when I refer to numbers now, it's on the new list, okay? 4-4, Singh. There is a report that while we were arguing motions, he stuck his head in the door and then was directed out. Now, he did not report to the deputy hearing anything, but we may want to make inquiry of that at the appropriate time.
We obviously moved for cause as to having, even if he heard a word or two that he should not have heard, it could be.
Well, we'll figure out what actually happened, but just hold that thought, Mr. Rosenfeld.
Was Your Honor able to obtain any video recording from the hallway?
We're working on it. It's not recorded continuously.
Sure.
Neil put in a request on Friday, and so I don't know whether we've captured anything or not, or what it would show.
Great, thanks.
You were correct, Nibs is not coming back.
Okay.
So chalk one up for her. She's off. 3-9 is Roland, he says he's sick, right?
3-9, yes, that's correct. And I'm going to call the other three right now.
Who were the other three that were missing by number?
Missing by numbers 2-6, 3-7, 4-1.
So 2-6 would be Peterson. 3-7 would be Gratian. And 4-1 would be Lambert. And they're all day one people. Are the rest of the jurors coming up?
No. I'm going to call these first, find out what they are. Hello, is this Larry? Okay, this is courthouse. Are you on your way? You on your way now? Hold on one second. Hold on. This is Mr. Peterson. He said he had his daughter call in this morning. She didn't get any phone calls downstairs. He's got high blood pressure and he wasn't feeling well. He could be here in about an hour.
Move to strike.
Mr. Williams? All right, that's juror, what's the juror number again? Let's see.
Juror 2-6.
2-6. Mr. Peterson, by agreement, we're going to strike.
You don't have to come in and okay? No, you're good for another year until they call you, okay? All right. All right, you're welcome. Hello, is this demonstration? This is 87, same 97. So you don't come to jury. I'm sorry. I'm sorry. She said I had the wrong number and hung up, Judge.
I suspect you had the right number.
That's the number I was given.
Which number again, Gratian, would be 3-7?
3-7.
Okay, so what do you want to do with her? I mean, I can't wait all morning for her. What's that? Well, they show up after I've started voir dire. They're going to be released. But Mr. Rosenfeld, Mr. Claypool, 3-7 is not here, not reporting to us. You ready to strike?
Strike.
All right, Gratian. 3-7, we're going to strike. 4-1's our last one missing in action. Lambert?
Goodbye, Mr. Lambert. We would move to strike.
Well, we're making a phone call first.
we're getting a recording for Mr. Lambert.
Counselor, what do you want to do on 4-1?
Can we just leave him a message on him simply for formal evidence?
We can, but you got to wait for him to get here?
No, it's just keep over. He shows up in 5 or 10 minutes and nothing's going on.
Well, when we go back down, we'll see if he's here. If he's not here when they bring up the rest of the jurors, I'm going to strike him. Okay, Neil, the rest of them, are they coming up? Or? Okay. All right, what I'm going to do then is I'll step off again until they're lined up. And then we'll get started. What's that? 4-1, we're waiting just to see whether perhaps he showed up downstairs, but if he doesn't come up,
Can you
we're
cover
going to
your
start.
docket? The gentleman's here for your docket.
Judge Kastrenakis in my courtroom. Yes, 11. Should be signs out there. Okay, I'll step off until our jurors are up.